what is the law and what the law to be. How can be law defined? How can be law interpreted for their own benefit, for the society benefit? So this is the meaning of law and its significance, relevance of law to the society and jurisprudence of legal theories. And there are many schools of law. Schools of law, this is various schools of law, but the philosopher name over given there, this is the Austin, Roscoe Pound, Salmond, Simony, Bentham, and etc. All these philosophers, it belongs to the Austin theory. This is known as the positive law theory. But apart from these, there are many also schools is over there. We will discuss, and I will try to explain you that what are the differences between all these three. Second is that we will discuss in my second lecture. This is the Constitution of India. It will be covered in three lectures. So second, third, and fourth, we will cover the Indian Constitution. Then fifth lecture, this is the interpretation of statutes. We can see that there are many topics spread over there, but this is not so lengthy. So we will cover in my one lecture the interpretation of the statutes, and the lecture 6 deals with the admin law. This is the admin law, and this is very useful for the common people of the society, because administration is having given the more power. This is the discretionary power, this is the quasi judicial power, this is the quasi legislative power. So we will discuss this syllabus also by many perspectives. Then law of tort is also, this is lecture 7, and 8 will cover the law relating to civil procedure. Then after we will discuss the law relating to criminal crime and its procedure. So that means it will cover the Indian Penal Code and Criminal Procedure Code as well. So then I have also classified into two categories, this lecture 9 and lecture 10. So first we'll cover the maximum laws which are belongs to the substantive law. This is the Indian Penal Code, and then after we will come into the Criminal Procedure Code. Then after lecture 11 is over there. This is also belongs to the criminal law. This is the procedural law. What are the various trials to be conducted by the criminal court while any case pending before him, and some crimes is also can be seen, forgery and defamation, and offense against the property and the property marks. Then we will move ahead. Lecture 12, this is law relating to evidence. Evidence means when any case is pending before the court, both parties, either the defense lawyer or the public prosecution, will try to prove their cases in their own favor. And in the support, what are the documents will be given by them? This is known as the evidence. So we will discuss also in my lecture 12. Then after lecture 13, this is also a part of the evidence, because this is a very important subject. So I have classified into two my lecture. Lecture 3rd is related to the Specific Relief Act. This is also a part of law of contract. We know what are the contract. Then after the matter is the victim, the aggrieved person is entitled to the compensation or entitled to the specific performance of the contract. The second part, specific performance of the contract, will deal by this subject. This is known as the law relating to Specific Relief Act. Then law relating to limitation. No doubt we know about that every person has two rights. First is the judicial right, and second is the extrajudicial right. Judicial right means when you have a right to approach the court within the limitation period. This is the judicial right. But you don't have a right to any time you can approach to the court. That means the time limit has been given for each and every case. If you have been beaten by any person, so you have a time period, and within this time period you have to approach the court. After this, you don't have a right to approach the court. So this is dealt by the law relating to limitation. This is known as the Limitation Act. Then this is 16th lecture. law relating to arbitration, mediation, and conciliation. This is a mechanism to resolve the matter speedy, quick, and less expensive. You know that when we file the case before the civil court, who will mm, alive to listen the judgment of that particular matter? No doubt, the plaintiff will never alive, because it is too lengthy procedure. First we file the case, second first appeal, second appeal, high court, supreme court, and no doubt there are three generation will expend their whole life, and the grandson, grand to grandson will listen the judgment of the that particular case. So that means this is the lengthy procedure. To avoid the lengthy procedure, to avoid the so expensive procedure, this is the new mechanism, and given in the also civil procedure code, and also given through the new act. This is known as the Arbitration and the Conciliation Act. So this will built by that act, and we will cover in my 16th lecture. 17 is Indian Stamp Act. This is Indian Stamp Law. We will also cover in my 17th lecture. 18 is belongs to the registration of document. So the registration of document, that means this is related to immovable property. It might be the belongs to the movable property, but we will discuss upon which subject matter it will be applicable. Right to Information Act. This is very important, and this is a very democratic act. We can say that every person has a right to know everything what is going on in that country, and this has been given right first time by Supreme Court in the year of 1982. We will discuss it also. Right to information. Then after many dimensions can be seen, and ultimately the act was passed in the Congress government. Then after many improvement can be seen in this area. Law relating to information technology. This is known as the IT Act, and because it's the technology era, and everything is going online in soft copy mode, not in hard copy, not in offline. So this is very important. This is very useful, but that doesn't mean that there are no any demerits. There are many demerits of this act. We can also discuss in my 20th lecture. This is the 21 law of contract, is very useful because this is the commercial age. This is the industrialization, and every person entered into a contract in their daily life. What are the rights of the parties to the contract? What are the duties? And if any parties is to perform their rights part, that what are the remedies available to the second party? And this is also a part of the contract. Then law relating to sale of goods. This is belongs to the movable goods, not the immovable goods. So what are the rights of the buyer? What are the rights of the seller? And when the contract is completed, where the contract is completed, what what would be happened in the online transaction, all will cover. What are the conditions and what are the warranties? We will discuss. This is also a very good subject, so I classify into two my lecture, 23 and 24, and last one is the law relating to negotiable instrument act. So this is entire syllabus we will discuss in my upcoming 25 lecture. So we will start from the jurisprudence, and this is the unit first, and sources of law. The name is given of this unit is sources of law. That means we have a law. First means we would like to know that what is the law, what are its importance, what are its significance for the society, and then after we will come to the jurisprudence. So that means if we can see the Indian Constitution, Article 13, subclause 3A, the terms law has been defined over there, but this is not defined over there in a broad sense. This is only for the part 3 of the Indian Constitution. Why it is necessary to be defined the terms law over there? because every person has been given a fundamental right. This is the sixth fundamental right. You know, this is the part 3 of the Indian Constitution. From the Article 12 to Article 35. There are six fundamental rights has been guaranteed by the Indian Constitution, and these are available against the state. Some fundamental right has been given also against the citizen and the peoples, but the maximum fundamental right has been given against the state. And Article 13 subclause 2 is saying that the state cannot make any laws which are taking away our fundamental right. So that means state cannot make any laws. What is the laws? That the terms law has been defined in Article 13, 3 subclause A. So law means, it is very much clear that law means order, ordinance, rules, regulation, usage, custom, everything. So that means anything is enacted by the parliament or the state legislature, that is also law. If any order passed by the any executive officer, this is also laws. Any rules, any regulations was made by any person, this is also laws. And any uses and any custom which are prevailing in the society, which are running in the society, and every person followed them, this is also laws. So that means if all such things are taking away your fundamental right, that things must be declared by the Supreme Court as a null and void. Recently you have heard about the triple talaq. This is not the laws made by the parliament. This is the custom. This is the uses followed by the Muhammadan only. But this is against the fundamental rights, because every person shall have a right to move everywhere, life to personal liberty. That means they have a right to choose everything, and every person has right to be equal treatment. So right, equality amongst the laws, and equal protection of law. So equality before law, that means if one person is treated as a, the second person must be treated also as a. There are no any differences. There are no any that can be said that the you cannot treat it as a two person as a two different things. So that means equality before law. So in Muhammadan era, in the Muhammadan religion, we can see that the husband has a very vast right to give the talaq to his wife, but the wife don't have any rights in that particular matter. So that the court has declared this is against Article 14, right to equality, and it is arbitrarily, which are also insane Article 40, and this is also against the doctrine of natural justice. So that means law means made by the parliament, made by the competent authorities, and also which are exist in the society as a usage and a custom. Now the question is that we can see article 20 subclause 1 ex post facto laws. What does it mean? It means every person can be punished by the existing laws, the laws for the time being in force. If any law is not present over there, it not in existence, the person cannot be punished. For example, A has taken any property which are in possession with B. Without the consent of B, A has taken that property. If any law is not existing over there, what would be the punishment for that act? That means A will never punished. And Article 21, you can also see that We have a right to life and personal liberty. That means every person must be deprived from their life and personal liberty except according to the procedure established by law. That means laws must be there and procedure must be there. Then after you can punish any person. So what the mean by law? For that particular purpose, Article 13 3 subclause B define what is the existing law. Existing law means only the law passed by the competent person. If any person has authorized to enact any laws, rules, regulation, that means that is known as the existing law. That means usage and custom is not the existing law. And by the usage and custom, to exercising the usage and custom, to using the usage and custom, you cannot punish any person. That means law is of two types, civil laws and criminal laws. Criminal laws means who providing the punishment that must be passed by the competent authorities. But civil law means any laws including order, ordinance, usage, custom, and rules, regulation, everything. Article 20 subclause 1 read with Article 13 3b is a different thing. It is explaining regarding the criminal laws, but Article 13 subclause 3a talk about the civil laws. So after using the civil laws, you cannot punish any person because the usage and custom is not enacted by any competent authorities. So the next is that relevance of law in civil society. What would be if there is no law in the society, and if there is a law, we are looking everything. What are the consequences? But if there is no any law in the society, what would be happened? And whether this is progressive or not. This is the question. This is also a point of discussion. That means society with laws, society without law. Judgment with laws, judgment without laws. We can see in the Britain, there are no constitution. They don't have any written constitution. What the judgment passed by the court, this is the constitution. Maximum, I think there are 80% laws over there made by the judiciary only, and only few laws thereafter, after taking the cognizance passed by the judges, that was coded by the parliament in the Britain, and that is declared this is the enacted by the competent authorities. Otherwise, maximum laws was made by the judiciary. You know that the doctrine of negligence, strict liability, this all things was made by the judiciary. In the when we will discuss the law of tort, you can see all the theories, all the doctrine was propounded by the judiciary only. Then after this was codified later on by the parliament, and that has been given the separate name. But before this, the first time it was only propounded by the judiciary. That means society without law, that would be the progressive society, because there are no any limit of the reasonability, reasons, thought, learning process of any person. If I am appointed as a judge and I am having the limitation that I can give the decision only this sphere, we cannot go beyond that. This would be not a proper justice if I have been awarded any, if I have awarded any decision. But If I have been given open sky, I can think anywhere, anything. That it is possibility that I will award the proper and perfect decision, and the uh, person, the victim who will get the decision, who will get the remuneration, compensation, that would be the appropriate, because the fact and circumstances of each and every cases is not similar to the law made by the parliament. The lawmaker does not know what is going on, and what the issues may be um, uh, originated between the parties, uh, what would be the consequences of the contract. That may be very fact to fact, and circumstances is quite maybe different. So that the award could not be same as earlier given or made by the parliament. It is depend upon the fact and circumstances of the cases that might be different. So the judges should be independent, should be free from any boundary, should be free from any limitation made by the parliament. So the society without law is very useful to awarding the compensation, to awarding the remedies, to awarding the justice. But what about the societies, the person who is living in societies? This is not be good, because every person shall have the king, every person shall have the supersede over the other person, will try, no doubt. So the society will be hampered. That means law is important. When the law is important, it is need to be defined. What is the law and what the law ought to be? This is the matter of the jurisprudence. That's why the jurisprudence come into the picture, to define what is the existing law, whether it is proper or not, and what the law ought to be for making the improvement for the society. So that means jurisprudence does not deal with any particular area of law. It will discuss about the law which are exist in society, and whether it is proper or not, and if it is not proper, what would be the perfect suggestions to make it proper and reasonable, just and fair for the common people of the society. Every person time to time has tried to define the laws. Many philosophers, many jurists has tried to define the laws time to time. Someone saying is that law is an instrument to control the conduct of human being. This is the terms human being. It is later on defined. Its definition is originated later on. But in ancient days, law means to control the activities of everything. When there are no any sovereignty, the societies are free and they are governed by their religion. And every religion is quite different. They are having their own opinion, their own God. They believe their different uses and customs. So that means on that time, the subject matter of religion, like a law, is not only of human being. Every person falls in the ambit of that religion. This is known as the tit for tat. If your animal making a nuisance on that particular time, that animal shall be punished. But later on, Justice Coke has given a doctrine. It is known as the actus non facit reum nisi mens sit rea. This is very famous doctrine given by the Justice Coke. actus non facit reum nisi mens sit rea. That means the person shall not be guilty for their act unless and until and unless they don't have any guilty mind. So that means actus reus as well as mens rea must be there at a time. Guilty mind and your act both are against the laws, then after you will be punished. Who will create the guilty mind? No doubt. Only human being, not the animal. Animal don't have create their guilty mind. What are the mind they have? They can exercise only. But they can create their good mind or guilty mind. So the only human being are made a subject matter of the laws, not the animal or not the other creature in the world. So that means what does it mean by law? Law means law is an instrument who regulate the conduct of human being, not other than the human being. Only the subject matter is now the human being. Then Alpian. Alpian has also tried to define the laws. This is the very famous jurist, and he said that the law is the art or science of what is equitable and good. That means it is the matter of law. He will decide what the conduct of human being is good and what the conduct of human being is not good, which are equitable and which are not equitable. If any laws classified the categories of the human being conduct, this is law. If it is not classifying, that means it is not law. This is Alpian. But this is not a very good definition can be said, because there are many more laws exist in the societies which are not classified any activities into two categories. Like that, civil procedure. Civil procedure is also a laws. Criminal procedure. This is only a procedure, but also as laws, this is followed by the criminal court and the civil court as well. But this is not law, because this is only provide the procedure to be followed by the court to awarding the justice and for making the trial. Then Cicero. Cicero is the second jurist person. Uh, they said law is the highest reason implanted in nature. They believe the regions. They believe the human mind. That means they are equivalent to the living law. And after there, the Ehrlich, this is the next one, the jurist, which follows the Cicero and which also explain the Cicero and the said the law means what is that? This is the law must be living law. That means according to the society's law should be changed. As far as society change, law should be changed accordingly. This is the living law. So that our constitution maker is also aware about that principle and also make the constitution flexible and also rigid in sense. They can be amended later on by using the power given in Article 368. If our constitution is not amendable, that means it is not a living law. Later on, the society will be changed. You cannot change our constitution, and that would be the meaningless for our next generation. So the amendment process is also given over there in our Indian constitution. And recently, I think 105th amendment has been completed. You should check once. Then after, uh, we are also talking about the jurisprudence. We are discussing that. Jurisprudence and legal theory. Jurisprudence, there are two terms you can see: juris and prudence. Juris means law, and prudence means the knowledge, not only the knowledge. Prudence means systematic knowledge. That means when we are talking about the systematic knowledge of law, that is the jurisprudence. The person who has a broad knowledge in the laws and talking about the systematic knowledge of the law, that is the jurist, and what are their ideas, what are their thoughts, that can be treated as a legal theory. Every person cannot give their legal theory if they don't have a broad knowledge, deep knowledge, thorough knowledge in legal field. That's why the certain person has named as a legal philosopher, and his theory, whatever they given, followed by various countries when they are going to adopt, when they are going to constitute their constitution. That means jurisprudence means this is the science of laws. Systematic, if you are talking about the systematic laws, that means this is the science of law. So that means the study of law